So welcome back to Simplify, the podcast where we help families navigate the biggest transactions with confidence. Today we're talking about one of the biggest assets most families own is their home, and some of the estate planning decisions that can unintentionally create major legal, financial, and family problems. And joining me today is Margaret Rintoul from Blaney, McMurtry. Margaret has over 40 years of experience in estate planning, estate litigation, guardianship matters, and complex family estate disputes. And Margaret is often the person people call when they have matters such as this. So, Margaret, thank you for joining us.
Well, thank you, Ryan. Yes, you're right. I've been doing this kind of work for longer than I care to remember, and I think I've seen probably all of the mistakes that people make. Although I'm always open to seeing new mistakes. It's quite quite intriguing how things can go wrong.
Great. Okay, great. Before we dive in, can you tell us a little bit more about your practice? So after 40 years in the field, what keeps real estate law interesting?
Well, estate law stays interesting because it's always going to have some different nuances. Every estate or every person's will plan has its own nuances, and so that's what kind of keeps it fresh. Also, our government keeps changing rules on us, which does cause a certain degree of having to stay current, and also often forces people to look at their own plans and make some changes to adapt to it.
Yes. Well, you're often dealing when situations where things haven't gone exactly according to plan. What are the common themes that you see?
Well, I do both litigation and estate planning, so I do see both ends of the spectrum. Because of the litigation side, I do tend to kind of go to the worst possible outcome because I've seen the 1% of things that don't go right. I'm also quite aware that there are, the vast majority of family situations are relatively straightforward, but we're looking at as an aging population where a lot more common law relationships, multiple family relationships, and so forth. And whenever you're into any of those sorts of things, you're into a more complex situation where you're the will kit that you can get online for $29 just is not going to cut it for you.
Yes, I bet. Are you hearing a lot of people saying, "Oh yeah, well now with ChatGPT, I can just go on there and make or change my will. It's just so easy these days."
I haven't heard that per se, but I have seen the will kits. I mean, the online versions are just the online version of what we used to nickname the grand and toy will, where you could buy the fill-in-the-blank form. So the concept that, oh yes, you can do it at home in 10 minutes and everything's fine is not new. The consequences of doing it and doing it wrong are also not new. They've always caused problems.
Yes. Great. Okay, well, I thought I could go through a few sections here. We could start with some of the biggest planning mistakes you see people make. So what are the most expensive estate planning mistakes you see people make?
I think that probably the most expensive mistakes and a consequence is not having regard for the liquidity that's going to be involved at the time of a death. There's especially for people who don't have a lot of liquid assets, where the majority of their assets are tied up in real estate or possibly investments that are hard to liquidate. And they can certainly plan how they want their estate to be set up, but if they haven't taken into account the liquidity that's going to be needed to pay income taxes and even to pay probate fees and general estate expenses and debts and so forth, the estate is not going to go as anticipated, and you can wind up with either bequests that can't be met or properties that were intended for individuals that have to be sold. So it can really, I think the liquidity issue is probably one of the biggest things that people don't recognize. And also where registered funds with beneficiaries come into play on that, because with most people having a lot of their liquid assets tied up in registered funds, particularly RSPs and RRIFs, the tax consequences there are quite serious when a person dies, and that's a big portion of their estate, and it's not just going to a spouse.
Interesting. Okay. And are you finding these mistakes are usually made because people didn't plan, or because they received well-intentioned but incomplete advice?
I'd say both.
Yes. Okay. So what are some of the things people can do to to avoid some of those pitfalls, especially people who don't have the kind of liquid assets that you mentioned?
Well, I think they have to recognize that if you've got real estate that is not your principal residence and it's gone up in value, then anticipate that somewhere somebody's going to have to come up with enough money to pay the tax on the capital gain, and the rule of thumb, it's 25% of the gain is going to go out in taxes.
Yes.
Same thing with RSPs or RRIFs. Recognize that unless it's going to go to a surviving spouse, up to half of the value of that account is tax. So you can look at your $1 million RSP and say, well, I've got $1 million estate, and there I'm going to start doling it out, but you've only got a $500,000 estate.
Right. And then the other biggie, and you mentioned property in Ontario that's not your principal residence. The biggie in Ontario is obviously cottages. It seems like a lot of people have cottages, and how to handle that situation. We can get back to that later, but yeah. I know that's a big one that people have to deal with.
Oh, it is a huge one, and I had a almost funny, but for the family it was not funny at all. Trying to deal with some very illiquid things, equity golf club memberships.
Oh yes, I've heard that. I'm sure art's another one too.
It can be.
Yeah. Do you find that many people are trying to avoid probate fees without fully understanding the consequences?
I'd say probably 75% of the ones who are obsessed with avoiding or reducing probate fees don't understand what's involved. First of all, it's 1.5% of the value of the estate. So yes, it's a significant bite. It's $15,000 per million, but it's not nearly in the class with income tax, and a lot. So the kind of knee-jerk response to reducing probate fees is to start into the joint tenancy, and we'll just make somebody a joint owner, so it'll pass automatically to them, and that is not necessarily the best planning device for the rest of, depending on what your overall circumstances are.
Right. Okay. So I was actually transitioning out to joint ownership. People, as I say, you said people hear all the time, just put your child's name on title. Is that actually good advice?
Generally, no.
Okay.
There are certainly there's circumstances where it makes sense. If you've got one parent, the other one has died, you've got one child, they're living with their mother or father, or they're close by, they're not in any particular financial issues themselves and so forth. Maybe it makes sense. But in the vast majority of cases, I'll add one of my 4 children as a joint owner of my house, would be probably one of the worst things you could do.
Oh, no.
Because,
and why is that?
Well, you're going to say, oh, well, John will do the right thing and he'll split it once with his sisters, won't he? Uh-huh. And
Yeah.
you will have John's wife, who may or may not be involved in this whole thing, but if John is on title and he and his wife split up, all of a sudden you've got this potential that your own house is part of their matrimonial property fight. And if John is in business for himself, where he has potential creditor exposure, or if he's not the best property manager or money manager and he gets into financial trouble, all of a sudden, at least half of your house is available to his creditors.
Oh my goodness. Okay. So why do people do it?
Because they get this advice from whatever sources they're relying on, that joint ownership is the way to avoid probate fees or estate administration tax, because it passes automatically, and they don't think about the other consequences.
Yes.
So they may save $15,000 in probate fees by having their $1 million house transfer without probate, but some of the other consequences, like having their son's trustee in bankruptcy looking for half of the value, could be considerably more devastating.
Right. Right. If it's a cottage or an investment property, what are some of the additional tax issues that people should think about?
Well, first of all, if you're just saying, I'm going to add my daughter or my son on title to the cottage, you're probably triggering at least a portion, likely half of the capital gain right then, because you're giving up a portion of the ownership. Now you can defer it until your death by doing some sort of a trust agreement where they say, I'm holding it in trust for mother. But if you've done that, then strictly speaking, you have not avoided the estate tax or estate administration tax, because when the executors have to fill out that form, one of the things they have to check off is fees payable on property held in trust for the deceased. So you've just gone full circle and you've gotten nowhere.
Right, right.
The other thing is, even when it's a principal residence, you can run into the situation where you had your own principal residence, and now there's an owner where it's not their principal residence because your child has their own home. So you may run the risk of losing some of your principal residence exemption on the balance of the value.
Got it. Got it. And I often hear people talking about buying investment properties, and they say, I'm going to buy this investment property and I'm never going to sell. I'm going to leave it to my kids. What pitfalls do you see with that?
Well, it's the same problem. I mean, sure, you can leave it to your kids and they're supposed to hold on to it in perpetuity because it's got all this rent coming in and whatnot. But recognize that when the original purchaser dies, whatever increase in value has come through is taxable as a capital gain, which takes me back to that liquidity issue I mentioned at the beginning.
And often you see kids that are inheriting are at different stages in life or different financial situations, and one might want to keep it and one might want to, cash out.
Oh, for sure.
Yes.
They're different stages in life. They're different financial situations. They're different geographical situations. The daughter who's moved to Vancouver isn't wanting to or able to look after a rental property in Scarborough.
Right, right. Or pay for and maintain a cottage in Lake Muskoka.
That's right. Exactly.
So are there any situations where you would recommend joint ownership?
There are times, like I say, if you've got one child who's stable marriage, no other potential limitations and financial burdens and so forth, and it's your own principal residence, and you're confident that it can stay your principal residence for as long as you need it. It may be appropriate, but it's something that really has to be thought through. The other thing too, just on that joint ownership, is if you've got a joint owner and they have to be part of a sale. So if you've got a property that is going to have to be sold to finance a retirement home or something, and all of a sudden your new joint owner says, no, I don't think we should sell now, you got a problem.
Right. Got it. So if somebody out there has already added a child to title, is there anything they should do now?
Well, I guess, either they can ask to have it back, which may or may not be welcomed.
Yes.
They can try to put some sort of trust declaration in place where their child agrees in writing that this is how they're going to handle it. Now, it may defeat the purpose of saving the probate fees that you were aiming for in the first place, but it may be a better approach than just hoping for the best.
Right. Okay, another thing that's becoming much more common is second marriages. What makes estate planning different for blended families?
Well, it's just the fact that it is a blended family. You've potentially got children from the first marriages of each of the new spouses, and there are likely intentions on both sides to look after the new spouse to a more greater or lesser extent, but also have assets available for their own children. And so that creates a fair amount of planning obligations. There's a variety of ways of handling it, but there's no perfect solution. Like the classic one where the new spouses sell both of their respective houses and buy a new house and take it in joint tenancy just creates potential for disinheriting the children of the first to die and giving a real big windfall to the children of the second one to die.
Right. That was actually my next question. Have you seen situations where children are unintentionally disinherited?
Oh, yes, unfortunately, yes. I don't know, maybe it wasn't unintentional, but it was certainly that's the impact.
Right. Talk about the thought that, a 3-year common law relationship is being similar to the rights of being married. Is that a myth?
Yeah, that's the urban myth that's been going around for the last 40 years. And there are certain provinces that have recognized common law relationships for all purposes, but Ontario is not one of them. And where if you don't have a will, and you're in a common law relationship, the common law spouse does not have any property rights in your estate. You can you can give them rights by making a will that sets things up properly, and to some extent cohabitation agreements or domestic contracts can deal with it. But the people who go ahead saying, well, I don't need a will because my spouse will get everything after all we've been together for more than 3 years, that spouse is going to be in for a rude awakening if a death occurs under those circumstances. I mean, I've had multiple situations over the years where someone sits in my desk, across the desk, and says, but we were living together for 20 years, surely I'm entitled to something. And I have to tell them, no, you're not. You're not financially dependent, so you can't claim that you're entitled to support, and you're not entitled to a share in the assets that he or she had in her own name.
Interesting. Another one I've heard recently is a situation where a couple gets together, one of the partners, say the woman owns a home, and the gentleman doesn't, and he moves in, and the kids are worried about any sort of, you know, they're worried about the gentleman and what they could do to protect the mother. And what they've said to me is, oh, we get him to we get him to pay rent. Does that protect her in any way?
Well, I mean, if they are married, it does.
They say they're not married. Let's say
they're
they're
not
just a
married,
boyfriend, girlfriend.
Yeah.
Just
And
partners.
Yeah. Yes and no. I mean,
Okay.
if he's paying rent, in theory, number one, he doesn't have an ownership interest to begin with. And if he's paying rent or some sort of occupation rent or sharing of expenses and so forth, it may backfire, because he can then say, well, I've been putting all this money into this house over the last 10 years, so I'm entitled, by way of what the legal term is constructive trust, to some sort of compensation for what I've put in.
Interesting. Okay. Well, there's another myth busted. So
And
if
the other problem too is that if you get someone who becomes a tenant in the legal sense, then all of a sudden you are subject to all of the Residential Tenancies Act provisions that protect tenants from being evicted.
Sure. So if things go south, it's then turns into an issue of asking the gentleman to leave.
Yeah.
Okay. All right. These are good to know.
Yeah.
So if someone's entering a second marriage and owns a home, what conversation should happen before getting married?
Well, they definitely have to have the hard discussion about is what's mine going to remain mine, and what's yours going to remain yours, and we will govern our affairs accordingly. And if that's the case, then they probably need a marriage contract or a domestic contract to set it out properly. It's not the most romantic thing in the world, but it is something that, if both parties are coming in with substantial assets, or if one has far greater assets than the other one, a contract is something they really have to seriously consider.
Got it.
That's particularly with the matrimonial home issue, because the Ontario rules and under the Family Law Act are that if a property is considered net family property, which the matrimonial home is, then the entire value of that property is divided equally between the two spouses. Doesn't mean they automatically get the bricks and mortar, but they are entitled to that value if either the estate or on a divorce they are down to dividing the matrimonial property.
Okay,
and
that's interesting.
If the intention is, well, you're moving into the house that I owned with my first husband, and we've paid it off, and I intend to keep that as my asset, the only way to maintain that situation is a contract.
Got it. Okay. Well, that leads into my next question, was how do couples protect each other while also protecting children from previous relationships? Is that contract something that could, protect children, keep everything?
Up to a point.
Yep.
But it's not ironclad, because a marriage contract or domestic contract is a contract between the two spouses, but it's not a contract between the children. The only parties who are bound by that contract are the husband and the wife, or the two spouses. So the wills that they prepare are usually the best protection that they can give to each other and to their relative or their offspring. And oftentimes, particularly in the second marriage, more older couples situation, part of their domestic contract will be that they agree that they'll each make a will that leaves the other one no less than whatever they're doing in this current one and provides for their respective children.
Interesting. Okay, well, let's go to the next question, which is about family cottages. You know, every family has the dream of keeping the cottage forever, passing it down from generation to generation. Is that always realistic?
Unfortunately, no. And well, even in families where they are really committed to keeping the cottage for the next generation, going back to my liquidity issue at the beginning, if you've got a cottage property with $250,000 worth of tax owing on the capital gain since you bought it back in 1975, then unless there's $250,000 of free cash around in the estate, there's no way to keep the cottage.
Got it. So this is something that a lot of people don't realize.
Yeah.
What do you find creates...
And then the other side too is if you've got, as we were talking about before, family at different ages and stages and geographic locations, your 4 children or 3 children are not all equally interested and equally committed to the property, and so the one who isn't going to use it doesn't want to be saddled with the expenses for the ones who are.
Right. And that actually leads to one of my next questions is what creates the biggest conflicts with these cottage properties in families?
Once you get past the issue of having paid the tax to get it up to the next generation, probably the issues of access and expense. I've seen people quite effectively figure out access schedules and who's going to pay what and so forth. Some families are able to deal with that. Not all of them are.
Yes. Do you think it's wise to have parents sit down with their children and ask whether they actually want the cottage?
Yeah, that would be the first step, because you may find out that you've got one who's very committed to it and others who could care less.
Mm-hmm. Yeah, exactly.
Maybe there are, depending on other assets available, maybe it's possible to work out an arrangement where, the one who really wants it can get it with whatever arrangements they can make. They may even have to foot the tax bill themselves, and then there's other assets for other beneficiaries.
Right. If one child uses the cottage more than, say, the other two, would you say that everyone should inherit equally?
Oh, God, no. That's one of those unanswerable questions.
Got it. Okay. When would you say for these family cottages that selling is actually the better option?
Well, I would think it's if you've got if there is no family member who really wants it and who is committed to maintaining it, then probably the best thing is to put it on the market.
Got it. Okay. Next, I wanted to talk about choosing an executor. You mentioned in passing that choosing the right executor is critical. What should people thinking about when choosing an executor?
Well, I guess, the number of things that they need to think about. Is this person that they're thinking about appointing, do they have the time to commit to dealing with an estate administration? Because it's probably the better part of 2 years of part-time work that they're going to be involved in. Are they physically and mentally able to do it? Do they have enough financial acumen to at least be able to understand what's involved and to know when they have to hire other professionals to assist them? And are they, if you're appointing one person, can they get along with the other people that you're naming as beneficiaries? If you're
Right.
naming, two people, can they even get along with each other?
Exactly. Exactly. Does geography matter in the situation we are talking about before, where one child moves to Vancouver? Does that really matter, or should they
Not as
be in
much
the?
as it used to.
No.
Used to be that, everything had to be signed in hard copy in front of a notary or a commissioner of oaths and so forth. And so the person, if you were in Vancouver and the estate's in Toronto, it was quite difficult. It's less so now, where so much can be done electronically, but
Right.
there's still the element of physical proximity. If you've got a house that has to be cleared out to be put on the market and so forth, the executor that's here is inevitably going to wind up with a bigger burden amount of work to be done than the one who's 5,000 miles away.
Right.
The other thing that does have to be considered, at least in a number of families where they've got some of the family have moved out of Canada, if they're, the most common one is they're living in the States, and naming an American as one of your American resident as one of your executors can be problematic.
Oh, interesting. I hadn't heard that. What can happen with an American executor?
Well, a couple of different issues. One, that you have to get a court order to dispense with an administration bond, because even if they're named in the will, if they're not resident in Canada or the Commonwealth, they have to post a bond, or you have to get an order to dispense with it, which is not huge. It's not a huge problem in most cases, but it is still an extra step. If it's for the most part, the rest of it, once you get past the bonding issue, is not too much of a problem with a U.S. resident executor, unless you've got an investment portfolio that's going to have to be managed, because the securities rules in Canada and in the U.S. are such that, for the most part, a U.S. resident can't maintain a Canadian investment account.
Ah, okay. Okay, interesting. Interesting. Should brothers and sisters always be co-executors, or siblings?
It depends whether they get along with each other. I think I've heard these things. Well, I'll name them both, even though I know they don't get along very well, because it'll force them to come together.
Do you find that works?
No, rarely.
Should a second spouse and adult child from a previous marriage act together?
It could work,
Yes.
or it could be a disaster.
Fair enough. Is it better just to get a professional to avoid some of these pitfalls?
Up to a point, but I mean, a trust company usually they have about, from my experience, a threshold of about $2 million before they'll even take on the estate at all. So for much smaller estates, that's not a viable option.
Okay.
Some lawyers seek out and are quite willing to be appointed as executors. I, for one, have not, but it is an option. Some people are comfortable doing that. Same with accountants. They have the expertise to do it. Whether they have the inclination is another matter. People do get very hung up. Oh, well, I don't want to incur executors' fees by going to a trust company or going to a professional. And, it may be false economy, and it may not. The fact is that any executor, even if they're an individual who are relying on outside legal and accounting advice, they're entitled to compensation too. So
Right.
just the fact that you say, oh, well, I've named a family member and they don't have to be paid doesn't necessarily apply.
Right. Right. Okay. I wanted to chat now about powers of attorney. Uh, Choosing an attorney for property or personal care seems simple, but is it?
Again, it's one of those situations where it's almost more important. I would say it's more important, at least to the individual, because they're still alive, than choosing an executor, because you can potentially wind up with a power of attorney in play for looking after the affairs of an incapacitated person for 10 years or more.
Right. Right.
And so there's a much more day-to-day involvement for a much potentially longer period of time. So the issue of naming someone who's prepared to get involved and be involved for a long time, that's a big issue. Getting more than one person and the two of them able and willing to work together, same issue.
Mm-hmm.
Having someone, sort of goes without saying, but the people get worried about, well, I don't want this power of attorney falling into the hands of the person I've named as an attorney because they might do something. Well, if you're worried that they might do something that would be harmful to you, you shouldn't have named them in the first place.
Right. Right. What qualities should people look for in a power of attorney?
Well, I mean, again, in the terms of the property power of attorney, someone who's got enough financial expertise and common sense to know how to manage someone else's finances, at least hope that they have had enough experience managing their own that they'll be able to take on someone else's effectively. In terms of personal care, you need someone who is of the same mindset as you are, because they're going to be making medical and care decisions that you would be making if you were still able to do so. So you're looking for someone who has the same values, morals, understanding of things that you do. I think that would be the main issue.
Okay, great. And then the next section I wanted to cover was real estate. We've covered a lot of when it comes to real estate, but a lot of people that are looking are homeowners. Should families speak to, my question would be, if someone's thinking about downsizing, when is a good time to review their estate plan?
Well, the standard we always tell clients with wills is you should, get it out of the drawer every 3 to 5 years and just see if it's still relevant to your needs. And you should look at it whenever there's some sort of major change in your own or your family's circumstances, the death, a birth, a divorce, all those things are reasons why you should look at it anyway. If, in your situation of the downsizing, I'm going to sell the big house and buy something smaller, it may or may not be probably a good time to look at the will and see if it still is appropriate. But just the fact of changing from house A to condo B is not necessarily going to impact your estate plan unless it's tied up with, well, I've now met a new spouse and we're both selling and we're moving into something, my money's going to go into buying this condo and his money's going to stay in investments. All those are places where you really do have to start looking carefully at planning.
Got it. Okay. And then lastly, we're going to end here with some rapid fire questions.
Okay.
So joint ownership, overused or underused?
I'd say it's overused.
Okay. Biggest misconception about probate?
that it's to be avoided at all costs,
Okay.
and that it will tie your estate up for years. People have, some of this comes from the US models that you hear about on television and so forth, because a lot of the US states, when they put a will, an estate into probate, or so-called, it's much more hands-on and direct involvement of the courts than it is here in Ontario. Here in Ontario, you file the paperwork, you pay the fee, you get your certificate issued back from the court, and the executor then uses that to liquidate assets, sell real estate, file tax returns, and so forth. And unless there's serious problems down the road with accounting and fights with beneficiaries and so on, the court has no further involvement. So this business of, I don't want my estate tied up in probate for years, maybe it may be an issue in some of the US states, but that by itself is not the problem here.
Got it. Okay. What's one estate planning mistake you wish everyone could avoid?
Coming up with all sorts of things they want to do for individuals in terms of giving them things and not recognizing where the money's coming from.
Okay. Great. Well, Margaret, thank you so much for speaking with us today. If someone wants to learn more, to reach out to you, where is the best place to find you?
Well, they can go to the Blaney McMurtry firm website. Just Google search Blaney McMurtry and the website will come up. And my own email is just mrintoul, MRINTOUL at Blaney, BLANEY.com.
Perfect. And I'll put a link to your site at the bottom or in the comments here so people can find you easier.
Right.
Margaret, thank you so much for joining us today. It was very informative. I really appreciate your time.
All right. Thank you so much.